Welcome back to FI's YouTube channel, the place where we talk about AI ethics and regulation. I will be going through fines under the GDPR and the role of artificial intelligence in this context. One of the most talked about fines under GDPR so far has been Facebook's £500,000 fine from the Information Commissioner's Office, and this was for serious breaches of the data protection law. The ICO's investigation found that Facebook processed personal information of users unfairly. Facebook also failed to keep the personal information secure because it did not do checks on apps and developers using its platform. This meant that Facebook data of up to 87 million people worldwide was harvested without their knowledge. A subset of this data was then shared with other organizations, including the parent company of Cambridge Analytica, who were involved in political campaigning in the US. The ICO found that the personal information of at least 1 million UK users was amongst the harvested data and consequently put at risk of further misuse. The Federal Trade Commission also formally announced its $5 billion settlement with Facebook this summer, after a long investigation into Cambridge Analytica scandal and other privacy breaches. The $5 million fine is the second largest fine ever levied by the FTC. Now, crucially, GDPR fines are designed to make non-compliance a costly mistake for businesses, regardless of its size. The most serious infringements may result in a penalty of up to £17.5 million, or 4% of the business's global turnover. When it comes to consent, it must be explicit. Automated decision-making and profiling is regulated in Article 22 of GDPR, which is included within Chapter 3, Rights of the Data Subject. So, applying all GDPR security measures becomes an essential step in order to avoid data breaches and Data Protection Authority fines, and this can be done by using pseudonymization and encryption of personal data. The ability to ensure the ongoing confidentiality, integrity, availability, resilience of processing systems and services. The ability to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. Lastly, a process for regularly testing, assessing, as well as evaluating the effectiveness of technical and organizational measures for ensuring the security of the processing. However, the use of AI requires some additional measures to safeguard the data subject's rights and freedoms, as well as the legitimate interests, which are the right to obtain human intervention on the part of the controller, to express his or her point of view and to contest the decision. Aside from Facebook, Google, British Airways and the Marriott Hotel are also facing some of the highest fines imposed under GDPR. France's Data Protection Authority issued €50 million fine to Google on the grounds of poor transparency and deficiency in information with regard to the personal data being processed, plus a lack of consent in relation to the delivery of personalised advertising. The ICO intends to impose a fine of over £180 million on British Airways for the theft of customers' personal and financial information, and £100 million to Marriott Hotel for accidentally exposing 339 million guest records globally. The British Airways and Marriott data breaches have nothing to do with AI, but could you imagine what the fine amount would have been if AI was involved? Feel free to share your thoughts in the comments below. If you need assistance with AI auditing, FI can help. We perform AI ethical audits and data protection impact assessments. Check out fi.co.uk for more information. We'll leave a link below, and in the meantime, we hope you enjoyed this video. Please like, comment and share it, and be sure to subscribe to this channel for more content in the future. Thank you for watching.